Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm joined as always by Miki Matrician, the co-managing partner of our Boston office. How are you doing today?
Doing well. Hi, Kim.
Hey, good to see you.
See you.
All right, so this week we're going to discuss a document that USCIS published on birthright citizenship. We have discussed the ongoing developments in previous Rapid Fire Wednesday episodes. So, just as a quick recap, on January 20th, 2025, the Trump administration issued an executive order to end birthright citizenship to children born to undocumented immigrants and to children whose parents are here in the U.S. on a temporary non-immigrant status. The executive order aimed to make it a requirement for a child born on U.S. soil to have at least one parent with U.S. citizenship or lawful permanent residence to acquire U.S. citizenship. So a flurry of lawsuits were filed immediately in the courts, and federal courts halted implementation of the executive order through nationwide injunctions. Then the U.S. Supreme Court issued a decision in June saying that federal district court judges cannot stop federal policies through nationwide injunctions, including for this birthright citizenship executive order. The Supreme Court decided that such injunctions could be issued only to individuals or specific groups who brought the suit, but left open the possibility of other ways to bring suits such as class action lawsuits. Immediately after that Supreme Court decision, the ACLU brought a nationwide class action lawsuit in New Hampshire, and the federal court in New Hampshire blocked implementation of the executive order, which was due to go into effect in July. Because it was a nationwide class action, that block was effective nationally. So, Miki, can you briefly address what's happening on this front with the other lawsuits that we're seeing?
Yeah, on Wednesday last week, a federal appeals court's decision blocked the executive order, stating that that executive order is unconstitutional. And that decision was issued by a panel of judges on the Ninth Circuit, upholding a lower federal court's decision that blocked the executive order in the first place. And the Court of Appeals said that the nationwide block is narrow enough and permissible under the Supreme Court's decision under the Trump versus Casa case, and that the executive order is invalid because it directly contradicts the language of the 14th Amendment. And then on Friday, July 25th, in a completely different case, the federal district judge in Massachusetts granted a preliminary injunction blocking the implementation of the executive order, saying that the Constitution confers birthright citizenship broadly, including to persons within the categories described by the executive order. And that case was a suit brought by 18 states and 2 municipalities. And it cited to Supreme Court precedent and that the president doesn't have the power to decide who becomes a citizen at birth.
So, as I was looking at these, Miki, I love that it's two New England states, the judges in those states that are assisting with the birthright citizenship injunctions and blocks. Nevertheless, I guess on Friday, July 25th, the USCIS did publish an implementation plan for the executive order. Again, the courts came out with their decision, and then now we have an implementation plan. And this document acknowledges that the executive order is blocked from being implemented due to a preliminary injunction, but that the US government has a plan to implement the executive order in the event that the executive order is permitted to go into effect. So the plan basically aims to clarify how it is defining some terms used in the executive order. So just as a reminder, the executive order says that the following categories of people would no longer be considered to have U.S. citizenship at birth. And those are children whose mother was unlawfully present in the United States and the father was not a U.S. citizen or lawful permanent resident at the time of the child's birth. And the other category are children whose mother's presence was lawful but temporary, and that the father was not a U.S. citizen or lawful permanent resident at the time of the child's birth. So, Miki, can you explain to us what that implementation plan is aiming to clarify?
Sure. Previously, it wasn't clear how USCIS defined unlawfully present under that first prong. And in this document, USCIS clarifies that unlawfully present means someone who is here in the US after the expiration of authorized period of stay. And there's a difference between unlawful presence and not being in lawful status. That's a source of confusion for a lot of people. Someone who's unlawfully present includes people who entered without inspection or without being admitted or paroled. It also includes people whose visa status expired. However, if someone was paroled in while they don't have a valid non immigrant status, they are authorized to be in the US and are therefore lawfully present. And then someone whose non immigrant status expired, but their timely filed extension is still pending with the government, they're also lawfully present. Another category would be somebody whose non immigrant visa status has expired, but if their adjustment of status application, which is the last step of the green card case, was timely filed and pending with the government, they are also lawfully present. And then the other term that was further defined was the meaning of presence that is lawful but temporary. So, who is considered to be temporary? Basically, non immigrant visa holders, they're here on a temporary basis, as are parolees, temporary protected status beneficiaries, and applicants who meet the eligibility requirements. People who entered on the visa waiver program or SDAC, deferred action recipients such as DACA, and deferred enforcement departure recipients as well. Also included are individuals who were granted withholding of removal or deferral of removal under Convention Against Torture, people who were granted voluntary departure, satisfactory departure, or stay of removal, as well as IMACT 90 Family Unity beneficiaries, Life Act Family Unity beneficiaries, and citizens of Federated States of Micronesia, Republic of Marshall Islands, and Republic of Palau residing in the U.S. pursuant to Compacts of Free Association. People who are here lawfully and not in temporary status include those people who are lawful permanent residents, conditional permanent residents, refugees, asylees, U.S. nationals who are not citizens of U.S., and American Indians born in Canada who entered the U.S. under INA 289. So, what does that all mean? It means children whose mothers are here lawfully in those non temporary, so more permanent categories, would not be impacted by the executive order. And so they would receive U.S. citizenship at birth, even in the event the executive order was implemented.
That's a really good breakdown, Miki, of who's lawfully present and who would be eligible for US citizenship. So thanks for breaking that down for everyone. And hopefully we don't have to deal with the implementation plan. But until then, we'll wait and see how this all works out in the courts. I know that we were expecting something to go potentially into effect on July 28th with the courts and their injunctions. And right now we're in a holding pattern. So I appreciate the update on all of that. It's super helpful. And so, with that, I guess that wraps up this week's Rapid Fire Wednesday. We'll continue monitoring legislative, regulatory, and court developments, as well as agency guidance, and provide updates in future episodes as we hear of them. So, as always, for the latest updates to the immigration landscape, please follow WR Immigration on LinkedIn, as well as Miki and my personal profiles for breaking updates and insights. And we also transcribe our Rapid Fire Wednesday episodes and share it weekly in a newsletter, which you can subscribe to. The link to subscribe can be found in the video description. So thanks for joining us, and we'll see you next time. Great to see you as always, Miki.
Good to see you, Kim.